Our next speaker writes about libertarian theory of law, contract, constitutional law, and jurisprudence. Professor Ramsey Barnett is a senior fellow at the Cato Institute and the Goldwater Institute. His book, The Structure of Liberty, won the Ralph Gregory Elliott Book Award in 1998. In 2008, he was awarded the Fellowship in Constitutional Studies by the John Simon Guggenheim Memorial Foundation. In 2009, he drafted the Bill of Federalism, 10 proposed amendments to the United States Constitution designed to limit federal power and strengthen our individual rights. Professor Barnett is a law professor at Georgetown University Law Center, where he teaches constitutional law and contracts. Today, he will speak on rediscovering the libertarian roots in the Republican Party. Professor Barnett, welcome.
Well, thank you. I want to thank Aaron Bitterman for inviting me to speak to you today. And thank you, Laura, for that introduction. I've been talking so much about the health insurance mandate lately and have been writing so much about it that I decided to take this opportunity to talk to you about something that is really completely different and of great personal interest to me. But I should begin by mentioning that I am not a Republican. But then again, neither am I a Democrat. And although I certainly am a libertarian and have been since college, I don't support the Libertarian Party either. Instead, I root for whatever candidate or party I think has a realistic chance of advancing the cause of liberty, of individual liberty. But recently, I've accidentally become familiar with the libertarian origins of the Republican Party, a topic that I thought would be particularly appropriate for the Republican Liberty Caucus. For several years, I've been studying a long-forgotten band of libertarian constitutionalists who in the 1830s, 40s, and 50s denied that the United States Constitution was pro-slavery. They advocated enforcing the text of the Constitution without any gloss put upon it by the intentions, understandings, or deals that were not expressly included therein. They contended that Congress not only had the power to ban the international slave trade, which everyone agreed, it also had the power to ban the interstate slave trade, to abolish slavery in the District of Columbia, in the territories under Congress's jurisdiction, and in any states formed from those territories. They also contended that the Fugitive Slave Acts of 1793 and 1850 were unconstitutional. These positions put them at odds with the other abolitionists that we've come to call the Garrisonian abolitionists, a rival group of libertarians who claimed that the Constitution was a covenant with death and an agreement with hell because it sanctioned slavery. When I finally began writing the paper about these folks, I wanted to include biographical information about each member of this forgotten group of libertarian constitutionalists. Gradually, I noticed that most of them had something in common. Unlike the Garrisonians, many of whom became anarchists, these libertarians favored political action. Most were involved in organizing the expressly anti-slavery Liberty Party as an alternative to the pro-slavery Democrats and the compromising, equivocating Whigs. So I figured I needed to learn more about the Liberty Party. So to do so, I turned to an excellent book that I highly recommend to you. It's called Ballots for Freedom by Richard Sewell. Ballots for Freedom, Anti-Slavery Politics in the United States, 1837 to 1860. Available on Amazon. Now, in his book, Sewell describes what he calls political abolitionism, that unlike the Garrisonians, favored political action to attack what was then called the slave power. Sewell relates a very clear chronology. The Liberty Party, founded in the 1840s by these constitutional abolitionists, soon led to the Free Soil Party, which led briefly to a party called the Free Democrat Party, and finally in the mid-1850s to the founding of the Republican Party. Like many other historians of the period, Sewell gave very short shrift to the constitutional theorizing of these political abolitionists. What my study shows, however, is that this very same group of political activists advanced a powerful constitutional case against slavery, a case that was based on the protection of natural rights and the original meaning of the text of the Constitution. They formulated constitutional arguments that are remarkably persuasive when compared with those advanced by the Supreme Court in cases such as Dred Scott versus Sanford. In short, constitutional abolitionism was at the core of the Republican Party. Now, we're all accustomed to hearing that the Republican Party is the party of Lincoln. But I think that its libertarian origins would become clearer if we also remembered, or if we remember, that it was also the party of Salmon P. Chase. Now, although I suspect you've all heard the name Salmon P. Chase, if you're like me, you may not remember exactly who he was. Perhaps you know that he actually ended up being Chief Justice of the United States. Perhaps you even know that he was a politically ambitious rival of Abraham Lincoln who also wanted to be president. But what Salmon P. Chase stood for has been largely forgotten. For long before he was Chief Justice of the United States, Salmon P. Chase was among the most prominent and brilliant members of this group of constitutional abolitionists I was just describing. Let me tell you a little bit about him and what he stood for. Salmon Portland Chase was born in New Hampshire in 1808, the year that Congress abolished the slave trade. He was 9 when his father died, and he was placed under the care of an uncle who was the Protestant Episcopal Bishop of Ohio. After graduating from Dartmouth in 1826, he moved to Washington, D.C. to study law with Attorney General William Wirt. Being admitted to the bar in 1829, Chase returned to Ohio in 1830, where he practiced law in Cincinnati. In 1836, he was drawn into anti-slavery activities when a mob attacked an abolitionist newspaper in Cincinnati. Its editor, James Birney, chose Chase, then a rising young attorney, to bring a successful civil action against those who had destroyed his press. In the 1840s, together with Birney and others, Chase helped form the Liberty Party and became one of its leaders. Because he had conceded that slavery was constitutional in the original 13 states, Chase today has a reputation as a moderate, in sharp distinction from what is now called the radicals. But historian Sewell makes clear that this dispute was one among friends, since both sides equally desired the overthrow of slavery everywhere. As Sewell puts it, quote, "The great mass of free soilers were as much committed to uprooting slavery everywhere as were the most dedicated Garrisonians." And while Chase insisted upon the distinction between moral action and political action, he viewed the political as the means to the moral. Quote, "What we want in my judgment," he wrote in 1846, "is not resistance to encroachment, but direct aggression. Abolish slavery in the district, on the seas, in all places of exclusive national jurisdiction, employ no slaves on public works, give clear preference to anti-slavery men in public appointments, and all would be well," unquote. In 1845, Chase addressed the Southern and Western Convention of the newly formed Liberty Party on the question of the constitutionality of slavery. No less than 100,000 copies of Chase's speech were printed and circulated in pamphlet form. Chase declined to adopt the view expressed by other abolitionists that, quote, "no slaveholding in any state of the Union is compatible with the true and just construction of the Constitution." But he did favor instead its removal from each state by state authority. On the other hand, like every constitutional abolitionist I surveyed, he, quote, "would have it removed at once from all places under the exclusive jurisdiction of the national government," meaning the District of Columbia and the territories, "pursuant to, quote, the true sense and spirit," unquote, of, quote, "the Constitution rightly construed and administered." In 1846, Chase litigated the case of Jones versus Van Sant before the Supreme Court, and his argument was published in pamphlet form the following year. John Van Sant was an elderly Ohio farmer who came across some fugitive slaves from Kentucky and gave them a ride in his wagon. He drove them for about 14 miles before being confronted by agents of the owner. All but one of the slaves were recaptured. Later, the owner brought suit against Van Sant for the damages arising from the loss of the one slave and the cost of recapturing the others. He also sued Van Sant to recover the $500 penalty specified in the Fugitive Slave Act of 1793. In his Supreme Court argument, Chase challenged the constitutionality of the Fugitive Slave Act, which had previously been upheld by the Supreme Court not long before. He contested that the Fugitive Slave Clause of Article 4 delegated any enforcement power to Congress. In fact, it was a broad reading of the Necessary and Proper Clause that the Supreme Court had relied upon to justify the enactment of the Fugitive Slave Act, the same interpretation of the necessary and proper clause that's now being used to justify the individual insurance mandate. Chase countered a pro-slavery construction of the Constitution based on, quote, the intentions of the framers, quote, unquote, by appealing to what he called the plain import of the text. In addition, he employed a standard abolitionist technique of meeting claims about the supposed intentions of the framers with the opposite supposition. Given that the pre-existing state constitutions had, quote, guaranteed the absolute, inherent, and inalienable rights of all inhabitants or citizens, unquote, it could hardly be supposed, he said, that, quote, any state, especially any slaveholding state, would have agreed to a constitution that would withdraw from any of these rights the ample shield of the fundamental law and leave them exposed to the almost unlimited discretion of Congress. As authority for this claim, Chase quoted the words of the 10th Amendment. Notice here another forgotten fact worthy of note. Before the Civil War, it was the slave power who enlisted the power of the federal government to impose the Fugitive Slave Acts. And it was northern states who complained about the interference with their rights to protect free blacks, their own free blacks, from being kidnapped by slave catchers. Historian Eric Foner wrote that in these, and by the way, Eric Foner is a left-wing historian who's telling us this. In these and other strenuous efforts, quote, Chase developed an interpretation of American history which convinced thousands of Northerners that anti-slavery was the intended policy of the founders of the nation and was fully compatible with the Constitution, unquote. Because of Chase's efforts, Foner continued, the anti-slavery interpretation of the Constitution eventually came to form the constitutional basis of the Republican Party platform.